Welcome and thank you for joining me for this GJE expert talk. My name is Ross Cummings and I'm Director and UK and European Patent Attorney at GJE. I work with biotech, pharmaceutical and medical device companies, assisting them to devise and implement effective patent strategies to support investment in their new technology. So far, you've heard about the fundamentals of patents, designs and trademarks and unregistered IP rights, and also about patent portfolio strategy and lifecycle management. And I've previously spoken briefly about what you can patent. And now I'm going to go into more detail in relation to the types of information you need to gather together before you file your patent application, with a focus on the biotechnology and pharmaceutical practice areas. So my aim for this talk is to set out the main checks that you need to make before filing your patent application in biotech and pharma. And these will help you to know whether you are indeed patent ready. Now, the first of these is knowing what can be patented. And this will help identify when you are ready to contact your patent attorney. And I refer to my earlier talk where I've gone through this in biotech. The next is knowing what experiments you may need to do after your initial eureka moment, shall we say, and before filing a patent application. It's important to include enough data to support your patent application. Now, principally, this will revolve around confirming that your invention actually works, or that the idea that you want to claim is at least plausible. And lastly, in biotech in particular, there are a few further steps that you may have to take before filing your patent application, particularly if your invention relates to cells or other biological material. I also want to explain the importance of doing all of this before filing your patent application, as some deficiencies cannot be corrected with further experimental work or other work after filing your patent application. Now, I recommend that you involve your patent attorney early on in this process. While I wouldn't advise drafting a patent application until the right data is in place, discussing your plans with your patent attorney should help focus your resources on the key requirements and ultimately reduce the cost of the drafting process by avoiding multiple revisions and alterations as data is obtained. I usually outline claims at the start of the process to assist my clients in seeing how their patent might look and to clarify where the holes in the data may be. And once ready, a suitable set of claims can be adapted to a full patent application and made ready to file to support a strong future patent. Now, don't forget that it's also very important to ensure that your invention is kept confidential until you have actually filed your patent application. Early public disclosures must be avoided at all costs. But if this does happen, then there are situations where you might have some rights recoverable in certain countries that have grace periods. So please get in contact. Now, I have noticed a shift in the level of detail that investors in biotech now require in patent due diligence. And it's crucial to ensure your patents are strong. Insufficient patents will be spotted and given less weight in due diligence, as quality is much more important than quantity in this regard. So this process of getting ready for filing your patent application is very, very important, because your patents are key in stimulating investment in your company. Now, getting patent ready. So what do you need to get patent ready? There are a lot of formal requirements for a patent, but the three key substantive requirements that a patent must meet to be granted are that the claimed invention must be novel. Now, novelty is absolute. Is there an aspect of the claimed invention that is not described in the prior art? This can be as minimal as an additional nucleic acid in a sequence, or an additional biomarker, let's say, expressed in a target patient for a medical use. It really can be very subtle, but it has to be different. The invention must be inventive. Now, inventive step, or non-obviousness, as it's called in America, is assessed with reference to the closest prior art. Now, does the difference in your invention over the closest prior art lead to a technical effect? Is it surprising? Does it have some benefit that you wouldn't have expected? Now, this relative requirement is difficult to assess until you're actually in possession of the closest prior art, which you may well not be when filing your patent application. And it's good to make efforts to find this before you file your patent application. But the best way to guard against future objections in relation to documents you haven't seen before is to ensure that you have data supporting your invention showing surprising benefits, or at least demonstrating some kind of effect. Generally, I would say a graph or two goes a long way in a biotech patent application. Now, importantly, this data can be supplied to the Patent Office later on in examination, particularly comparative data with the closest prior art. And the next is the invention sufficiently disclosed? Now, this may require you to have experimental evidence. However, the key difference with inventive step is that sufficiency must be established by the day of filing and cannot be evidenced later. If you have all of these, you should be ready to file your patent application. But beware, depending on the type of invention, other steps may be required, particularly if you are claiming a new biological cell. Now, is your invention described in enough detail? Sufficiency of disclosure relates to the need for the invention to be disclosed in detail in the patent application. And there are actually two main aspects to the assessment of sufficiency of disclosure. The first is the need for a patent application itself to provide all that is necessary for a skilled person or someone who is skilled in your relevant art, so maybe a scientist working in the same area, to make the invention. So there must be enough information in the patent application itself for someone to actually make the invention. Now, this is a fundamental requirement in obtaining a patent, as it is your payment, as it were, for the state-granted monopoly. In exchange for a time-limited monopoly, the patent applicant must make the technical details of their invention available to the public so that they can be built upon and ultimately move technological progress forward for the benefit of society as a whole. If your patent does not describe the invention in enough detail, if you're trying to keep things back from the public and a skilled person would not be able to reproduce the invention, then you should not get a granted patent. Or as these do occasionally slip through the net, if you do get a granted patent, then it's not likely to be a very strong patent and it may not survive opposition or litigation. Now, a problem that can be encountered in biotech with this requirement is that there can be serious difficulties in describing an invention on paper if it is based on a complex biological system, such as a cell. There's just no way to describe this in writing. It's far too complicated. Now, to address this, most countries around the world signed the Budapest Treaty, which provides a list of secure cold storage facilities where you can deposit a sample of your biological material, be it a bacterial cell carrying a vector or a hybridoma making a monoclonal antibody, for example. This sample is verified and it can then be made available to third parties on request for the purposes of testing your invention. You can actually limit availability to your samples to a list of preordained experts, but the central tenet is that your sample is available should it become necessary. Now, you must mention the deposit accession number in your patent application, and you can therefore, we can refer to this and even claim your deposit in your application. This is particularly useful when your deposit is a hybridoma. If the patent applicant is not the same as the depositor, then you need permission to refer to the deposit. But the main thing is that the deposit must be made before you file your patent application to satisfy sufficiency of disclosure. Now, assuming you don't need to deposit anything, you must ensure that all required sequences and experimental details are in the application to allow a skilled person to reproduce the invention. Now, a further step that may be required if your invention is based on recently obtained biological material from abroad is checking whether you satisfy the requirements of the so-called Nagoya Protocol. This is another international treaty set up to ensure that countries benefit from their biological resources. I won't go into this in detail now, though. So the key thing is your patent must provide enough information for someone to make your invention and also make your invention across your claimed scope. So not just a part of what you're claiming, you need to have enough information in your patent application so that someone can make a sufficient quantity of the the claimed scope of your patent. Now, the next aspect of sufficiency of disclosure is actually often referred to as plausibility. And this relates to the evidence or data provided in your patent application. So more than just the disclosure. And this data must show that the invention is plausible. The sufficiency requirement may be met if the application contains at least one example that contains enough information so that someone may reproduce the invention, but as I've said previously, it really ought to support your invention across the whole claim scope. For example, a patent to a pharmaceutical composition must contain sufficient information to allow the composition to be made and to be administered to a patient. A biotech or pharma patent must also include sufficient information to make it plausible that the invention would actually work, even if it's clear how to carry out the invention. Now here, data is king. The applicant must provide sufficient experimental data to make the scope of their claimed invention plausible. Is it actually plausible that the disease could be treated with this drug? This is a question you must ask yourself. This can be a difficulty at the very early stage of the process that you're filing your patent application, because the applicant will almost certainly not have done any clinical trials. They may not even have done any in vivo tests. Nevertheless, they must still show that the ultimate claimed use of the compound is plausible. The reason for this is because biological inventions in particular are deemed inherently unpredictable. So any claim that something works must be backed up by experimental evidence and a clear logical rationale. Otherwise, you're possibly just claiming theories. Such experimental evidence is rarely needed in the mechanical arts to support sufficiency of disclosure, provided a skilled person would understand how something will work. And that, of course, is supported by the laws of physics. Nevertheless, aspects of this, shall we say, mechanical approach can be used to help explain in your patent application why the invention is plausible, even in a biotech application. Now, with a patent to an antagonistic protein, for example, a clear mechanistic link between the target and the disease, along with evidence in vitro testing that the protein specifically binds the intended target, may be enough. It would be better if there were cell-based assays with suitable reporters supporting the mechanism. Now, as patent owners, we can almost sense when there's enough in the disclosure, that enough's been done to achieve sufficiency of disclosure based on the facts. Certainly, some data will almost always be required, but the extent of which will depend on what the applicant wants to actually claim, as I've mentioned, along with what is known about the disease mechanism in question. If a lot is known about the target metabolic pathway and about relevant disease mechanisms, then it is likely that less data will be needed to make an invention sufficiently disclosed, provided your patent attorney is able to tell a convincing story in the patent application, of course. Now, this analysis is very specific to the facts of the case, and it's almost impossible to generalize. Fundamentally, if a third party trying to carry out the invention would need to exercise a degree of creativity to make the invention work, or a lot of experimentation, then it's likely that the invention would lack plausibility and therefore lack sufficiency of disclosure. A lack of sufficiency of disclosure cannot be cured after filing, so it is critical that these assessments are carried out before the patent drafting process. Another reason it is helpful to involve your patent attorney early on is that identifying potential plausibility issues during the experimental process is quite a challenge, particularly if you have in-depth knowledge of the area or an innate inventive character and therefore are reading the document at a level beyond the common general knowledge. In the US, they have a different assessment called written description, which has a lot of similarities to sufficiency. This is aimed at demonstrating that you actually had possession of the invention at the time of filing. Here also, data is king. So in summary, it's important to recognize what can be patented. There are a lot of exceptions to patentability in biotech and pharma, but there is almost always a workaround. This may be as simple as changing the language of a claim, or it may be a case of claiming around the problem, for example, culture media rather than stem cells. Know when the effect is plausible. Have you done enough to go from theory to plausible effect? Data is very important here for achieving sufficiency of disclosure, but also for demonstrating the inventive step. Have you taken all the necessary steps to ensure the invention has been described in enough detail? Do you need to make a biological deposit under the Budapest Treaty? The patent application must be a detailed instruction manual. The ultimate patenting dilemma in biotech and pharma is when to file. When are you ready? Far too soon, and the patent may be invalid for lack of sufficiency. Far too late, and you may be trailing behind your competitors who may have gotten there first and invalidated your patent for lack of novelty. Also, with the pressure to publish in science, there's always a risk that a journal will publish before you file your patent application. Now, all these considerations must be weighed up, but if in doubt, it's better to file earlier rather than later. Data can be included in the priority year by filing new priority applications or by including the data in your international application, as discussed in the last talk. Plausibility at the time of filing the international application may be sufficient, provided the data does not change the character of the invention and potentially undermine your priority date. However, the importance of the priority year will depend on the prior art in question. The complications and strategic considerations make it essential that you talk with your patent attorney early on and involve them in these decisions. This may be the difference between an invalid patent and a strong patent that supports investment in your company. Now, if you'd like to find out more or have any questions, then please get in contact. Thank you very much.